We got history, got me feeling the
Partnership is a form of agreement between two or more parties that agreed to build a business. In every partnership, there are corresponding articles that need to follow. I am Nakcidale S. Dieto.
This is Elma Ergen.
I am G, Pelesin.
I am Jackylou, Tomarong.
This is Markjayson, Balangyao.
I'm Marianne G, Magdale.
With Myra P. Padecio, and we will be discussing about Article 1784 up to 1794.
Article 1784. It says that a partnership begins from the moment of the execution of the contract, unless it is otherwise stipulated. This means that when we talk about partnership, it is a form of contract between two parties and mere consent. It is consensual contract. Partnership can be formed by mere consent as all the necessary requisites are present in the contract of partnership. Example:
A and B agree to form a partnership that will base on October 20, upon the arrival of machinery needed by the business. In this situation, parties A and B have no partnership yet because the agreement remains executory.
Article 1785. It states that when a partnership for a fixed term or particular undertaking is continued after the termination of such term or particular undertaking without any express agreement, the rights and duties of the partners remain the same as they were at such termination, so far as is consistent with a partnership at will. A continuation of the business by the partners or such of them as habitually acted therein during the term, with any settlement or liquidation of the partnership affairs, is prima facie evidence of the continuation of the partnership. Partnership at will is one which no term of existence has been fixed and which may be determined at will of any partners. When we talk about partnership with fixed term, it is a term of existence has been agreed upon expressly and impliedly. Expiration of the term thus fix the accomplishment of particular understanding specified will cause the automatic dissolution of the partnership. Partnership at will, it is a partnership that can be dissolved by will or either of the partners. If the duration of existence of the partnership is not indicated, then generally it is a partnership at will.
Elma and Myra decided to engage in selling of bags and slippers. Both parties agreed that the partnership will exist only during the said day, and the profit will be divided equally among themselves. The partnership form is considered as partnership in a fixed term. After that day, the partnership is automatically dissolved. On the other day, both parties still visited by customers and without any express agreement. Therefore, the partnership is dissolved with a fixed term, but partnership at will is created. In such case, the rights and duties of the partners remain the same, but only insofar as it is consistent with partnership and will because the duration of existence is not indicated. Article 1786 states that every partner is a debtor of the partnership for whatever he may have promised to contribute thereto. He shall also be bound for warranty in case of eviction with regard to specific and determinate things which he may have contributed to the partnership. In the same cases and in the same manner as the vendor is bound with respect to the vindi, he shall also be liable for the fruits thereof from the time they should have been delivered without the need of any demand. So basically, this article talks about contributions which every partner is obliged to contribute to the partnership. They have the responsibility to give their contributions, whether it is money, property, or etc., even if there is an absence of demand. Since it is a form of agreement, if a partner is not able to carry out its obligations properly, he is bound for warranty in case of eviction, and he will be called debtor because he failed to fulfill what he is obligated to do for the stability of the build partnership. Partner A promised to contribute land to the partnership but he does not fulfill his obligation. Since it is a form of contract, he will be liable for the interest and liabilities would come after him. Article 1787 states that when the capital or part thereof which a partner is bound to contribute consists of goods, their appraisal must be made in the manner prescribed in the contract of partnership, and in the absence of stipulation, it shall be made by expert chosen by the partners and according to current prices, the subsequent changes thereof being for the account of the partnership. This article talks about the agreed value and fair value of the partnership. In our accounting for partnership and corporation, we learned that before parties would come to build partnership, they account the value of assets and liabilities that they will contribute to the partnership. After the transfer of ownership, build partnership will account the contribution. If there is an absence of agreed value, experts comes in to determine the values of the assets and liabilities based on the fair value. For example, partner A decided to contribute land, and partner B also decided to contribute delivery boats on the partnership. Since there is an absence of stipulation, they decided to go to their chosen expert to determine the value of the assets and liabilities based on fair value.
Article 1788. A partner was undertaken to contribute a sum of money and fails to do so become a debtor for the interest and damages from the time he should have complied his obligations. The same rules applies to any amount he may have taken from the partnership coffers, and his liability shall begin from the time he converted the amount to his own use. Liability of partner for staffa. Failure to return the money taken, there is an element of fraudulent appropriation of the money delivered to a partner with specific instructions for the use of the partnership. Then, staffa is committed under the revised penal code. In this article, the partner will become a debtor of the partnership from the moment the partner fails to contribute the undertaken contribution to the partnership.
Elma and Myra formed a partnership to operate a cell phone repair service. Myra and Elma agreed to contribute 100K each on and before December 1, 2020. On November 29, 2021, Elma complied the agreed amount of 100K. On the same day, they have supposed customer with the estimated income of 10K. But because Myra did not yet contributed the amount and they did not yet buy the repair tools, they lost their client that day. On December 31, 2021, Myra contributed the agreed amount. So means Myra is already a debtor in the partnership and also liable to the amount lost on the first day amounting 10K. They can't operate the business because of the failure of Myra to contribute to the partnership, and they decided to buy business needs. But because of emergency at home, she converted the amount for her own use.
Article 1789 states that an industrial partner cannot engage in any business for himself unless the partnership expressly permits him to do so and if he should do so. The capitalist partners may either exclude him from the firm or avail themselves of the benefits which he may have obtained in violation of this provision with a right to damages in either case. Industrial partner is one who contributes his industry or labor in the partnership. Industrial partner barred from engaging in business. To prevent any conflict of interest between the industrial and the partnership and to ensure faithful compliance by said partner with his prestation. In this article, industrial partners are prohibited in engaging to any business where he should focus on their own, unless the partnership permits him to do so. If the partner forced to engage in any business, he might be excluded or the partnership can avail of the benefits.
Elma and Myra form a partnership in a dance tutorial. Elma is the industrial partner while Myra is the capitalist.
Aussie, 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 yeah. Come on, baby.
Elma's shift ends at 5 in the afternoon. Engaged to other business which is prohibited. Myra can exclude her from the firm with the right to damage or avail of the benefits which he may have obtained from the right to damage.
Article 1790 says that unless there is a stipulation to the contrary, the partners shall contribute equal shares to the capital of the partnership. This means that if the partners haven't any agreement about of their capital contribution to the business, then their contribution should be equal. Partner A and Partner B plan to have the total capital of 100,000 pesos. Then they have the agreement to contribute with a ratio of 60:40, which means that Partner A will contribute 60,000 pesos and Partner B will contribute 40,000 pesos. However, if Partner A and B haven't any agreement about their contribution, then they should contribute equally, which is 50,000 pesos in order to achieve their desired amount of capital. Article 1791 says that if there is no agreement to the contrary, in case of an eminent loss of the business of the partnership, any partner who refuses to contribute an additional share to the capital except an industrial partner to save the venture shall be obliged to sell his interests to the other partners. Imminent loss means that the business is going to bankruptcy. In this article, capitalist partner has the obligation to save the business from losses with the help of their additional shares. The industrial partner will not force to contribute his shares because he already gave his 100% to the industry. However, if the capitalist partner refuses to contribute additional shares, then they should sell their interest to the other partners who is willing for it.
Article 1792. If a partner authorized to manage collects a demandable sum, which was owed to him in his own name, from a person who owed the partnership another sum also demandable, the sum thus collected shall be applied to the two credits in proportion to their amounts, even though he may given a receipt from his own credit only, but should he given it for the account of the partnership credit, the amount shall be fully applied to the latter. The provision of this article are understood to be without prejudice to the right granted to the debtor by Article 1252, but only if the personal credit of the partner should be more onerous to him. In this article, there are two debts existed. If a partner owed amount of the partnership at the same time to the individual who is also a member of the partnership, the debtor has the choice where he will credit his payment. It's either to the partner or to the co-partner.
Article 1793 of Law Partnership. If a partner authorized to manage collects a demandable sum which has owed to him in his own name, from a person who owed the partnership another sum also demandable, the sum thus collected shall be applied to the two credits in proportion to their amounts, even though he may have given a receipt for his own credit only, but should he have given it for the account of the partnership credit, the amount shall be fully applied to the latter. However, in Article 1793, there is only one creditor, which is partnership. How it is discussed is when the debtor decided to pay his or her utang sa partnership. Credit katong mga partners being the co-owners of the partnership, you have rights over sa katong mga partners being the co-owners of the partnership. They have rights over sa katong gibayaran niyang utang sa debtor. In an instance nga naa sila share adto, why? There are instances that the one partner is kanang hakob. For example, there is partnership between A, B, C. The debtor paid his debt worth 100k, pero 50k ra yung gibayad. With the percentage share of the partners are 60-20-20. However, di kuha tanan sa partner A and put through her shares. The share must be A will get 40,000, B is 40,000, and A is 20,000. but partners A got it all. That is why Article 1793 comes that the partners is obliged to bring to the partnership capital what he has received, even though he have give receipt for his share only.
The article of 1794 of Law of Partnership, where Article 1794 discusses that every partner is responsible to the partnership for damages suffered by through his fault, and he cannot compensate them with the profits and benefits which he may earn for the partnership by his industry. However, the court may be equitably send the responsibility if through the partner's extraordinary efforts in other activities of the partnership, unusually profits have been realized. So, means nga, Article 1794 nga, in a partnership, every partner is responsible to the partnership damages. Any of them, any part of the partnership. So, any partner is responsible. For example, si partner A, na siya isa ka transaction about sa sales contract, tapos napalya. So, the fulfillment is not delivered properly. So, nag-create siya of damages instead of benefits. So, katong damages nga iya ang hatag sa company, syempre, iya tong i-shoulder. Siya dapat ang mo punad to. So, karon sa general rule, syempre, madawat yapon si partner o mga compensation and benefits sa company. But, ang damages na iyang gibuhat, dili ito niya masubject to set off. Otherwise, naamantay mga sa exemption nga na mga times nga maayon siya sa open field. Like, for example, ang sales niya, dili ito siya ma-justify for that kana nga sayop, pero the past few months maayo ay ang sales, so malesen ang liability nga pwede ma-shoulder kang partner. So muna pasabot sa Article 1794.
To wrap it all, the overall discussion on law and partnership, starting Articles 1784 to 1794, are very useful. And for us, this would serve as a guide for every entrepreneurs in building partnership and to know their obligations and responsibilities towards the business which they operate.